Good evening. Tonight we have a goal of starting the tax treaty area and getting as far as we can. We've got 3 more sessions, so during the course of those 3 sessions, I expect we'll spend a lot of that time covering tax treaties. And I think the best way to cover tax treaties is to discuss it with the treaty in front of us. So a lot of our discussion will be while we are looking at it to see what it says and discussing, well, what does it mean and what are situations where something might be relevant or important or have significance. So with that in mind, I'd like to first cover a few general things before we actually break out the language of the treaty. The first point to make is that a tax treaty itself is an agreement between 2 countries. The taxpayer is not in any way a party to the treaty. Taxpayer might be considered a beneficiary of the treaty, but he is not a party to it. The only parties are the 2 contracting states. There are around the world very few treaties that, in a sense, are multilateral with more than 2 countries. But as a practical matter, I think what you will use is existing bilateral treaties, just of course involving 2 countries. You have probably already heard me, and perhaps you've heard from other sources as well, references to model treaties. The one that's most commonly referred to as the OECD Model Treaty, Organization of Economic Cooperation and Development. We need to know, well, what's the significance of that model treaty? Is it something that we should study? And if yes, why? And in addition, we've also perhaps heard that under the OECD Model Treaty and under the UN Model Treaty, there are commentaries that are available for us to look at. And are they worth looking at? When would we want to? The first thing to say, I think, is that a model treaty does not exist for the benefit of taxpayers. Does not itself directly benefit any person who wants coverage by a treaty. Rather, what the model treaty is a document that is meant to be a starting point for 2 states to use when they start negotiating the terms of a treaty between them. It's something for them, it's a working document for them to start off from. That's why it's there. And as you look through the commentary, you will find various places where they will say quite directly, a state might want to do it this way instead of what's in the model treaty, if its objectives are this or that or something else. So the model treaty itself and the commentary, they're actually tools specifically for the 2 states that are negotiating the treaty. The point is that a model treaty and commentary are not actually written with the treaty user in mind. They are written for the tax administrators or treaty negotiators of the various countries. Now, having said that, since both countries are essentially using the same document to try to figure out what they're doing, the same model treaty, the same commentary which says which provides interpretation of what's there, then that's something that we can use as an indication of what perhaps the authorities had in mind when they agreed to a treaty, assuming that they use the standard treaty language that's in the model. If they decide to do something else that's not in the model, then of course the commentary interpreting that article might not be relevant. So when you're looking at the commentary for guidance on what an interpretation of a treaty term might be, your first goal is to actually say, well, gee, does the treaty in fact follow the model? Because otherwise the interpretation might not be relevant. In the domestic context, if Congress amends a law and you're trying to interpret a changed provision in the tax law, well, you can't go back to a court case that decided, let's say, an issue similar to your client's, but which was decided under pre-amendment law. If the law has changed, well, the old court case might not be so relevant. Well, the same thing here in the sense that if the contracting states have amended the language of the model, well, then maybe the interpretation doesn't apply. You've got to look at it and decide. Now, all of you have received a copy, I'm sorry, I shouldn't say have received a copy. I know there's a copy of the OECD Model Convention and commentary on the website. You also have access to this because as a student, you have the ability to download available books on the Source OECD website. If you have not gone to the OECD website and the Source OECD website, I highly recommend that you do so. Yes.
Is it the July 17th, 2008 condensed version?
Yes,
okay.
That's the.
I just want to make sure I have it right.
Yes, that's right. That is the most recent. Every so often, I would say on average, every 2 to 3 to 4 years, the model treaty and commentary has been reissued with all amendments. And the last one before that was 2005. So the 2008 one is the one that's current. I believe it's expected that another one will be issued this year with some changes. Do look at these sites and familiarize yourself with what's there. And the other thing I would say is, please, you are a student right now. At some point, of course, you have hopes of graduating and no longer being a student. Once you are no longer a student with access through the library, you cannot download things from Source OECD unless you pay them money. So I highly recommend that you spend some time looking at that Source OECD website. There's a lot of material in there, not only tax, but of course many other areas of international interest. And based on what is of interest to you, download a library of material. Otherwise, access to it is not as easy. You'll see, for example, that some things are freely available. So because of the transparency of the process by which the OECD makes amendments to the model convention and the commentary, you're able to get off of the OECD website. Anybody can get off. Anybody can access, for example, copies of discussion drafts or news items or other things that are in the OECD website. But things that once they get finalized and get published, then you might not be able to get something off of the OECD OECD website. You might only be able to go to the the source OECD website for a full copy. For example, I think that condensed version, I believe you can obtain a copy, and I don't remember which one it is, without payment if you don't have access like we do through the school. But I believe you can get a copy, but it's one of these copies that you cannot print, you cannot cut, and you cannot copy and paste from. It's a restricted thing. So do take some time while you have access to the Source OED site, Source OED site, and develop a library of material that's of interest to you. Now, I've been talking about the OECD. Are all countries members of the OECD? How many members does the OECD have? I actually don't have the slightest idea how many countries are in the OECD. But there's a limited number of countries because the OECD has traditionally been sort of a wealthy club of countries. On the other hand, the United Nations will take anybody that successfully claims some level of sovereignty. And there's several hundred.
It says 30 years, though.
It says what?
31.
Okay, so 31 countries are official members of the OECD. Thank you. But the point is that you're looking at 31 of the wealthiest countries versus 200 and some odd, maybe it's higher, I don't know, of countries that are in the United Nations. Now, if we look around the world and we say, well, gee, what's the average income level, sophistication level, economic level, what have you, of those 31 countries versus the average of all 200 plus countries in the United Nations? I suspect there's a bit of a difference. Now, that means that somebody speaking for the UN as a whole has maybe a different viewpoint than one speaking only for the most wealthy countries. There's a lot of developing countries in this world. They're not members of the OECD for the most part.
Well, this is an interesting fact. It's
Yeah.
on the page. Chile just joined on May 7th of this month. So they're the latest member of the, and then the next would be Slovak Republic in 2000. So it's been a long time since.
Okay. Yeah, I mean, Chile, I frankly have never been to South America, and I know very little, but I have, I have heard that Chile, relatively speaking, is from the standpoint of South America certainly, and I suspect worldwide, is a relatively well-off country with resources and people having a decent standard of living. So, in any case, the point is, the OECD, it stands primarily acting on behalf of more wealthy countries. The UN, the egalitarian organization that it is, stands more for the world as a whole, which means really the bulk of which is developing. So as you can imagine, there maybe are some different interests between the two. So the UN, because of this different interest, has put out its own model treaty. And in a couple of cases, as we work our way through the treaty, or through the treaty articles, we will look and see what a few of those differences are. And I think you will see that those differences are primarily ones of economics between developed countries and developing countries. There is also, especially I want to state because we are here taking this course within the United States, there is a U.S. model treaty, and that is the U.S.'s starting point for negotiations. What's of interest to us is perhaps not so much the U.S. model treaty itself, but rather the technical explanation of that model treaty does include some things regarding interpretation of what's in that model treaty, and therefore, to the extent that you're looking at a treaty which might follow the U.S. model, then perhaps you have a source for interpretation. Just one final comment regarding the model treaty and commentaries. I have suggested that for this course, and frankly, because I am more concerned because I'm more concerned in a sense for your future than I am for what you do in this course, I have suggested that you read through carefully the model treaty, and that's something that we'll again reinforce through our discussion tonight and over the next two sessions. But also I suggest that you scan through the commentary. Now, if you want to take the time to read in detail this, I don't know, 250, or maybe it's a 250-page book, roughly, if I remember correctly, then fine, by all means do it. But at least scan through to see the types of things that are there, so that you know when to pick it up, so you know what types of things you might find in there. That's very, very worth doing. You have an advantage today that I certainly did not have some number of years ago, and that is that if you want to quickly figure out, is there something in the commentary on a particular subject, you can do a search because you've got these things in soft form. This is very easy to do. Do it. Previously, I can say with some level of experience that unless you've scanned through something, especially where you cannot search with the tools we have today, it's pretty hit and miss on what you find unless you really learn what's in there. So anyway, learn what's in there and use the search function when you think you may have something that's relevant. Why do we have tax treaties? I think if we try to look at this from a broad sense, we have to say, well, the parties who are entering into the tax treaty are the two countries. They're not the taxpayers. So we have to, I think, maybe first ask the question is, well, why are countries taking the time and effort to enter into these agreements? Why do we have, I remember seeing a figure on this some time ago, and I want to say it was like there's either 1,000 or 2,000 tax treaties out there. A lot of countries have been very, very active at this. You might find a country that has 50 or 60 or 70 or 80 tax treaties with other countries. I mean, that represents a lot of time and effort. So why do they do this? The benefits that I'm marking up there are, I think, relatively specific benefits, but in an overall sense, I think countries are motivated by a few things. One thing that I think is pretty important is the desire to encourage their own residents to greater economic activity, because having a playing field that is more certain when a company goes overseas is a favorable thing. It helps your own residents if they have more certainty on how they're going to be taxed somewhere else. I think that's one factor. I think, frankly, from seeing how some of the countries operate, I think there's a prestige factor in having tax treaties. In any case, clearly countries are motivated to do this. They may have some altruistic motives for their own residents. They may also have some personal glory. But irrespective, this is a powerful force which causes us to have a very, very wide network of treaties. How do you find out if there is a treaty between two countries that you might be interested in? Where do you go to look for it and find it? Anybody looked at the bibliography for the course? Yeah.
The government website, there's always the tax authorities website. The IRS website, like for the U.S. there's IRS.
Okay, so for the U.S., there's the IRS website that will give you copies of treaties and the technical explanations. Is that going to help you if you're looking for a treaty between Japan and China? Probably not. Where would you look for the treaty between Japan and China? What do you have access to? Aha, smart man, Joey. You're going looking for the bibliography. Marissa as well. Okay. Just to shortcut it a little bit, while there are several sources, the one that I personally like is Tax Analysts, taxanalyst.com. Now, again, that's a member-only thing. And I would hope that you've looked at their website, because in the material for the course, you've got a username and password for that will sadly disappear sometime, I think, in June. Look on there and look at what's available in those databases. Now, I believe Tax Analyst is also, all of its treaty database is also provided, I believe, within Lexis. So if in your job or through the library or through the law school, what have you, if you have access to Lexis, you have access to that database. Take a look at it, and even if you don't really care which countries you're looking for, just look and spend 10 minutes to see how you find something. Okay, going back to, let's say, more specific benefits of tax treaties now viewed primarily from, let's say, the taxpayer standpoint as opposed to the country standpoint. First of all, exemption or reduction of host or source country taxation. You may recall that I said at some time, I think back when we were talking about maybe jurisdiction and the foreign tax credit, that the country of source, or the host country, has the first right to grab tax on income from that's within its jurisdiction. A tax treaty may restrict the host or source country and reduce the level of taxation, or even eliminate it. We've talked some about permanent establishments. The U.S., all of us know, have this effectively connected concept, and a U.S. trade or business, we've said probably 5 or 6 times, has a very, very low threshold. You don't have to do very much to have a U.S. trade or business and potentially effectively connected income. if the U.S. enters into a tax treaty with another country and accepts the permanent establishment concept, which is a much higher threshold, then the U.S. has reduced, to the extent it is a host country, it has reduced its taxation of business activities. Secondly, prevention of double taxation through exemption or foreign tax credit granted by the home country. Again, when we talked about foreign tax credits, we said that while I think today the majority of countries have a unilateral credit, I've at least run into, over time, a few countries that have had a bilateral credit. In other words, they will not just grant anybody a credit, they will only grant a credit for taxes that are paid to a country with which there is a tax treaty and in which there is a provision saying that we will grant our taxpayers a tax credit for that other country's taxes, or exemption as appropriate. Increased certainty. Now, we talked during the sessions, for example, on classification of income. We talked about sourcing rules, and we saw that there was potentially a lot of diversity. Well, a tax treaty, by defining what those categories of income are, by defining source for a defined category, that eliminates confusion and uncertainty because of this kind of situation. Equal treatment, non-discrimination. Or let's say that a domestic individual is allowed certain levels of standard deduction or exemption or something like that. But non-resident aliens are not granted those items. Well, that implies that a non-U.S. person, let's say, is treated worse and taxed higher than a comparable U.S. person might be. Well, if that's the case, the treaty for persons who have the benefit of this provision might be able to recalculate their tax on a basis consistent with how a resident would be taxed and be allowed a lower level of taxation. So, non-discrimination. Mechanism for dispute resolution, which refers to the competent authority procedure. If two countries have a dispute as to a fact or the characterization of a transaction that causes a difference in taxation, a double taxation effectively, or if there is a transfer pricing dispute, which again is sort of a disagreement regarding the facts of transactions. Under the treaty, you now have a mechanism for the two countries to talk to each other and to agree on some approach that will treat that item consistently between the two countries. Again, this is a mechanism that we'll talk more about later. But the point is that is a benefit of having a tax treaty. And finally, something that's become, again, more important in recent years, a mechanism for exchange of information. One of the nice things that will help you tremendously in your career is that you know what to expect you will find within any tax treaty, even though you haven't seen it yet. Although if we go back 75 years, there was a lot of diversity in tax treaties, or 50 years, a lot of diversity, there has been so much use by countries of the model treaty format that pretty much every treaty, the structure of it, looks for the most part the same. You know which article includes what. You know where to go look. Now, of course, you always have to go look at the treaty and see if in fact it does read the way you expect it to read. Maybe it won't. But 9 times out of 10, or maybe even higher, it will read the way you expect, and probably close to 99% of the time, it'll at least be, the thing you're looking for will be exactly where you expect to find it. This uniformity, this what I'll call common patterns, is very, very helpful to us. Now, what are some of these common patterns? Well, like I have just referred to, the layout, order of articles, and the content. Various terms that are defined are pretty much defined in usually the same place within the treaty, and very often they're taken word for word from the model conventions. Now, especially when you are using older treaties, which is becoming less and less often because countries have made a habit of updating through renegotiation their treaties, their treaty networks. With older treaties, you might find definitions being different and occasionally the order being different. Another common pattern is that the taxes that are typically covered are the national income taxes and state and local taxes, value-added taxes, excise taxes. These various other charges are not covered. Stamp duties, social insurance, those are not covered at all by tax treaties. The one exception is social insurance charges, where there are agreements, a limited number of agreements with various countries. They're referred to as totalization agreements, and they cover how individuals are to be treated if they are living in another country and paying social charges to that other country. So those are maybe an exception, that there are agreements for those, but they're pretty limited. Another common pattern is that there are a number of things that are not really covered by tax treaties, and they're left to local law. And 3 obvious situations that will often concern us are, number 1, corporate reorganizations, classifications of entities as taxpayers or transparent, substance versus form, and other anti-avoidance tools. Generally, treaties are silent on those things. We're starting to see a few treaties that will at least give rules on how you deal with, for example, a partnership or an LLC. But that's just the tip of the iceberg. I'm sorry, that's a bad analogy. That's really just the start. There's this huge iceberg of treaties that have no mention at all of this, but more and more commonly, of course, taxpayers are using LLCs, and treaties do not say how LLCs are to be handled. We'll talk a little bit about this in a few minutes, but anyway, that's one area typically not covered. We're starting to see a few treaties. China, for example, has entered into a few treaties where they specifically say that within the treaty that domestic anti-avoidance rules can override the treaty. I think that's because domestically in China there was a legal concern that if a treaty made an obligation, well, perhaps a domestic rule could not override the treaty. Other countries have not been quite so concerned about that nicety. Another general area is this one of conflicts between a treaty and domestic law, which will govern. Now, some countries will have a specific provision within their tax law that says if there's a treaty obligation, that treaty obligation controls. It trumps anything that's in this domestic law. Again, the Chinese tax law has such a provision. On the other hand, maybe domestic law and the treaties are silent on this, and under local law, the conflict is resolved based on time of enactment. Was the law passed most recently that conflicts, or was the treaty negotiated and ratified and entered into force more recently? And then we certainly find in the U.S. and occasionally elsewhere that domestic laws will expressly state that they override treaties. And the two very well-known examples on this are FIRPTA, which is the Foreign Investment in Real Property Tax Act. This was from the 80s sometime, and essentially made sure that if U.S. real property is sold, either directly or in some cases indirectly, there will be taxation on it. Previously there were some cases that a person could avoid taxation on sale of U.S. real estate, and that was felt to be wrong in a religious sense. So therefore, FIRPTA, by its terms, overrides treaties and was written in a manner to make sure that it overrode virtually every treaty, or perhaps all treaties. The last one there, Section 7874, regarding corporate inversions, I don't recall whether I mentioned this before. Let's assume you have a U.S. public company as a good example of this. And that U.S. company has shareholders, many of which are U.S. and perhaps some number of which are non-U.S. And let's assume that the business of that U.S. company involves activities both inside the U.S. and outside the U.S. You may recall that I said it's a terrible tax answer to be a non-U.S. person, own a U.S. company that then does business or makes investments outside of the U.S. That gives you a terrible answer because of this layer of U.S. taxation. So some number of companies over the years have specifically inverted in order to go offshore. So instead of having a public company in the U.S. that's owned by U.S. and foreign persons and then doing business inside the U.S. and outside, instead of that, they convert to a foreign public company in a tax-efficient location, which will have a subsidiary in the U.S. doing the U.S. work, a subsidiary outside the U.S. doing whatever operations there are outside the U.S. And that allows avoidance of U.S. tax on the foreign income, the non-U.S. income that goes up into that new tax-efficient location company, public company, and then when it gets distributed to shareholders, the non-U.S. shareholders, they are not hurt by a layer of U.S. tax. And U.S. individual shareholders, to the extent that they receive their share of earnings from overseas, U.S. individual shareholders or U.S. institutions that are tax exempt they are also better off by avoiding the corporate level tax in the U.S. on that foreign income. So that's referred to generally as a corporate inversion, and let us say that corporate inversions got a lot of bad press. I believe one of the items, either in one of the handouts or on the website, is about corporate inversions, if you're interested in the subject. But in any case, that got a lot of bad press in Congress. They made a lot of noise about it and eventually passed this Section 7874 to essentially make corporate inversions taxable. And in so doing, they're so expensive to do that you probably won't see too many of them. That's another area where, okay, the U.S. has expressly overrides treaties. There's always an issue of which comes first, the application of the treaty or the application of domestic law. Generally, well, this is, okay, there will, I'm sure, always be exceptions, but most generally, you are going to apply domestic law first to characterize and figure out legally what is the transaction. What is the relationship of the parties? Then once you've determined that under local law, then you go to the treaty and see how that particular issue is dealt with in the treaty. So a couple of examples. Debt versus equity. It's domestic law which characterizes whether a shareholder corporate loan is going to be treated as debt or equity. Is it real debt, or is it in substance equity and to be treated that way under domestic law? Let's say that you have determined that this document, which is labeled shareholder loan, you've determined that it's really equity. Now, because that's a real transaction that the parties are respecting, to the extent that there are terms for payment of interest, for ability to repay principal, there will be some cash flows coming back under this document from the debtor to the shareholder. Those are the physical cash flows. Now, you've decided that for tax purposes, the proper characterization of this is an item of equity of the shareholder in the company. So you now have to decide under domestic law, well, okay, what's the character of that payment? What's the character of the amount that was meant to be interest under the loan document, but which because you're characterizing the whole transaction as equity, you look at it and you say, well, gee, what is it? Well, again, using our U.S. rules, because we happen to be in the U.S. here, we might say, well, if this is equity, even though the document labels this payment as interest or as repayment of principal, we have to look at the E&P situation to decide whether the payment is to some extent a dividend. We have to look at that E&P situation to decide, is this payment a return of capital or a capital gain? Okay, once we have decided what those things are under domestic law, let's assume that we decided that some portion of that payment was a dividend. Okay, now we can go to the treaty, we can look at Article 10, which deals normally with dividends. We do not go to Article 11, which deals with interest payments, but rather because of our characterization of this under domestic law, we look at the dividend article and decide how it will be taxed. has a dividend. So while, yes, there's a definition in the treaty, and we have to look at that as well, generally the first step generally will be to figure out domestically, how do you characterize something. I'm sure there will be some exceptions out there where the treaty overrides a domestic characterization, but I think as a general rule, figure out what it is under domestic law, then look to your treaty. I think that's going to be the safest approach for how you interpret things and apply the treaty. Second example there, employment income versus director's fees. As we walk through the treaty later, you'll see that there's separate articles on how employment income is dealt with and how director's fees are dealt with. Now, we can talk later as to, well, why is there a difference? But the point is that there is a difference, and therefore, even though you may not really think of this as being a particularly relevant issue, whether an individual gets a payment due to his employment services or due to his activities acting in the capacity of a corporate director, there are some consequences for taxation in accordance with the treaty. So therefore we have to figure out, under domestic law, have we paid the guy a salary, employment income, or have we paid somebody something that is legally a director's fee? So this, again, is an example of where we need to characterize something under domestic law first, then we look at the treaty. Research and interpretation of tax treaty issues is unfortunately a relatively difficult exercise. And the reason it's difficult is that you do not have in one place, you do not have in one nice service like CCH or Prentice Hall or any of the other things that you find downstairs in the library. You don't find a nice source which lists out all of the court cases, all of the governmental rulings, all of the possible things which might help you when you actually have a problem that you have to solve. For example, maybe you have your client or the company you're working for is doing some activity in another country, and you're scratching your head and you're saying, gee, is there a permanent establishment or not? And what they're doing is sufficiently different from any guidance in the commentary, the specific countries that you're concerned about, because let's say you're in the United States and maybe the other country concerned is Japan. You've exhausted the research within those two countries and there's nothing there. How do you get to, again, governmental rulings or court cases that might be helpful to you? Things from other countries, of course, cannot be controlling, but they can certainly be helpful in your presenting something on this to local authorities or to a court of law or what have you. And there are a number of court cases where judges in various countries have at least accepted as an indication of what treaty interpretation might be, court cases and rulings and what have you from other countries. So the point is, how do you get to these things? And the answer is that there's really no good way. There's a few services out there, and I think I've mentioned I think I mentioned this in the overview. But this is a real difficulty. If you actually have a situation that's really important and you have to look for any straw out there, so to speak, to help you, the answer probably is that you have to decide, well, which countries might there be something out there, and then ask local counsel in those countries to do some research. To give you an idea of at least what kinds of things are out there, I strongly suggest that you go down into the library and you find the item which I think is in the reference section, which is entitled, I think it's Tax Treaties Service by Michael Edwards Kerr. I'm not sure whether Mr. Kerr is still with us or not. He stopped publishing in, I believe, maybe 1996 around. But he has a couple of volumes of, again, rulings, court decisions, what have you, organized by article, by treaty article. And it's one of the few sources out there that at least you can look and see what types of things are there. Unfortunately, like I say, the last update was in maybe 96. So it's, of course, slowly getting somewhat out of date from the standpoint of new developments that have occurred. But this is something to at least page through, spend 5 minutes paging through to see what kinds of things are out there. Just so you have an idea of that. There's one other item which I have never actually seen, but I know exists, and that's that the International Bureau of Fiscal Documentation has developed some new database of this kind of thing, but it's limited on coverage, and I don't have any personal knowledge of how good or bad it is. The definition of primary and secondary sources, I think, is perhaps a bit fuzzy, but in any case, let me use those terms here. Clearly, one primary source is the Vienna Convention on Law of Treaties, which gives the general principles of treaty interpretation. Again, it's not particularly useful in any specific situation. Rather, it's part of the background of what you need to know is out there. And I've indicated in the required reading just a few of the articles in that which you ought to scan, and again, just be aware of what's there. Secondly, if you are looking at a specific treaty, of course, which if in the real world you would be looking at the specific applicable treaty between the two countries concerned that affect your client, then you would, to the extent you find any, look at specific protocols, technical explanations, rulings, court decisions issued by those two states. An important issue is whether a document that you might find in one state, whether that document in fact has been approved or at least agreed to in some way by the other state. For example, I mentioned before that the U.S. model treaty comes along with a technical explanation. And further, if I don't know whether you've looked at this before, but most U.S. treaties, and maybe all of them, I'm not sure, but most U.S. treaties have, along with the treaty, a technical explanation which is issued by, I believe it's issued by the Treasury, although I'm not positive of that. In any case, the question is that technical explanation issued by the U.S. side, is that something that is necessarily agreed to or recognized by the other side? Do you think when the U.S. issues a technical explanation for, say, the U.S.-German treaty, do they necessarily go to Germany and say, this is what we're planning to issue, do you agree? And do you publicly say that you agree with everything in here? Now, I've never asked anybody within the Treasury or whichever body it is that writes these technical explanations, whether in fact they go and try to seek agreement from the other sides, but my sneaking suspicion is that they probably don't. And one of the reasons I say this is when I was working in Russia and looked at the technical explanation of the U.S.-Russian treaty, which was issued by the U.S. side, some of the things that were said in there were not things that I would expect would be calmly received by the Russian side. So my suspicion is that probably these are unilateral documents, these are not bilateral documents. A protocol, which is clearly something that is agreed to and signed by both sides, that's pretty solid. But a technical explanation that the U.S. issues probably is not. But if it's really important, that's something that you can try to find out about. The Model Treaty Commentary, again, I mentioned before quite a bit about the commentary, so I would consider that a primary source, again, using this somewhat loosely, the term primary, but I would consider it a primary source as long as the model convention language for the treaty article that you're interested in is in fact the same as the treaty that you're seeking to interpret. The fourth item, items that you might find in other countries that might be persuasive or might be helpful in explaining things, because that's some sort of an official document which is issued and at least can be potentially cited, both in your discussion with tax authorities as well as within a court of law. What about secondary sources? What is there? Well, there's a reasonable number of books out there, there's many articles, there's a lot of stuff which you can look at. One of the items that was listed in the bibliography I found quite interesting to read, how the permanent establishment concept was developed. This particular book, Permanent Establishments, Erosion of a Tax Treaty Principle, from 1991 by Arvid Skar, that's S-K-A-A-R. I found that awfully interesting in terms of detailed information about permanent establishments. This is on page 6 of the bibliography, the course required and recommended reading list. But in any case, there's a lot of things out there that you can find without too much trouble if you spend a little bit of time, of course, looking in the library or online to find sources. There is a lot out there. But in secondary sources, unfortunately, too often they will be of dubious value in terms of trying to convince somebody, because any of us can write an article on some topic, give our considered opinion of what something really means, and that's now a secondary source. Whatever the reasoning is, and its explanation is as good or as bad as the author of it. If we look at Article 1, we see Article 1 is, of course, very short and sweet, which is, this convention shall apply to persons who are residents of one or both of the contracting states. There's a number of areas that I'd like to cover with respect to this residency issue. We'll discuss them here, and there's, of course, more discussion in the overview. The first point, if we look at the treaty itself, if we now go over to Article 4, paragraph 1 of Article 4, we see that residence, as defined in the treaty, really is looking to domestic law. Now, I think we looked at the Hong Kong-China tax arrangement a few weeks ago, and we saw that there was an exception to this in that arrangement. But generally, virtually all treaties define resident in Article 4, and they define it by reference to the local law of the state to which a particular taxpayer is claiming residence. So this is something that is a basic thing to be aware of. And we've talked about residence before, where, again, there were various criteria for residence. Physical residence, for example, in the case of an individual, where is he physically located, where does he spend time? Citizenship for companies, management and control, or place of incorporation. So these are things that we find as various domestic law criteria. Again, a point is that you cannot look at a treaty and immediately say whether the taxpayer concerned is a resident, because it's not really defined in the treaty. It's a reference to domestic law, which may or may not be available to you. If you're practicing in the U.S. and the U.S. is the host country or the source country for another taxpayer from another country, then you cannot assume that that company is necessarily resident for the purposes of any treaty that the U.S. has. You need to be asking some questions about their domestic status in that country to decide whether under the treaty they are a resident and entitled to benefits. So again, important point, you cannot assume from just looking at a treaty that a company is going to, in fact, be resident, or an individual is going to be resident for purposes of that treaty. There's a number of special issues that I'd like to mention. The first one, and I don't recall whether I referred to this before in an earlier class, but if an individual is living, for example, let's say this is the U.S., this is Hong Kong, this is China. If an individual who is a U.S. citizen is living in Hong Kong, does that individual get the benefit of the U.S.-China treaty? There's nothing in the U.S.-China treaty which says anything about this kind of situation. But I understand that the posture of the U.S. authorities, the IRS or Treasury, is that that individual is not to be considered a resident of the U.S. for purposes of the treaty, even though he's taxable on worldwide income by the U.S. This is something that we find in the case of an individual like this with respect to, let's say, China. But what happens if this is Japan? Japan and the U.S. have a relatively recent treaty. Look at paragraph 2 up here. and read through that. So under this clearly stated rule, this individual is not going to get the benefit of the U.S.-Japan treaty unless he really does spend a lot of time in the United States, for example. There are a few treaties like this. I believe the new Canadian, or let's say not necessarily new, but the Canadian treaty, which has a protocol in it that was, I want to say from 2008, has a similar rule in it that would prevent an individual. So in the renegotiated treaties of recent vintage, you may expect to find something like this where the U.S. is not allowing treaty coverage for these individuals. To me, this is a bit surprising because since the U.S. taxes on a worldwide basis, why is the U.S. in a sense penalizing the individual and not allowing him the benefit of, let's say, tax protection or lower taxes in Japan? But irrespective of what the logic is, this is the way it is. Foreign-owned resident being non-resident for purposes of the treaty if taxed in home state only on domestic income. What does that mean? Let's say we have X in country A. It has a subsidiary in country B, which is a tax-efficient country, and it has Y has income from country C. And the question is whether the BC treaty will apply. Will Y, under the BC treaty, be a resident of country B, a legitimate resident of country B for purposes of the treaty? And essentially what this rule that is expressed in the commentary is, if Y is under some sort of special taxing regime, which maybe says that it must pay taxes in country B on income earned in country B, but because of its special status as an international company or some some sort of status, will not be taxed on any income from other countries by country B, then for purposes of the BC treaty, the commentary is telling us that country C can tell Y, we don't consider you a resident of country B, you are not entitled to the benefit of the BC treaty. So even though country B says, yes, under our domestic law, Y is a resident, C can reject a claim for treaty benefits because of this special status. Again, if you think about it, it's the concept of elimination of double taxation. One of the reasons for there to be treaties presumes that if you are eliminating a host or source country tax, then that income that would have been taxed, or at a higher rate maybe, will be taxed by the country of residence. So if you have some special regime, taxing regime in country B that encourages parties from country A and other countries to use the facilities, so to speak, of country B to achieve a tax benefit, then we're not really achieving the stated goals of what the two countries entered in the agreement for in the first place. So there is some logic to this. Triangular cases. I think you may recall that in one of the earlier sessions we talked about a situation of an American bank with a branch in Hong Kong making a loan to a Chinese borrower. That's an example of a triangular case. Another example would be, and I think we've talked enough about that one in the prior session to not repeat very much about that. Another case might be where you have maybe a partner in country A, a partnership in country B, and income earned in country C. So there can be triangular cases that involve 3 or more countries, and trying to figure out what is the country of residence, it has to be looked at carefully in these kinds of situations. With regard to transparent vehicles, most tax treaties do not mention at all partnerships or LLCs. It's only through some discussion in the commentary where at least there's some suggestions that the OECD is making. Some suggestions as to how to apply the spirit, so to speak, of the treaty itself. Now, this example is taken from the commentary for Article 23. Article 23 is the foreign tax credit rules, or the exemption rules. Remember, I said before, if you're looking at the commentary, you may find things in one area that you're interested in for some other purpose than just the area. So here we're talking about, in a sense, residency and who gets the benefit of a treaty and how things are viewed, but the example happens to be found under the foreign tax credit exemption article as opposed to Article 1 or Article 4. One of the issues with regard to partnerships is that each country may treat a partnership in a different fashion. Here, in this example, we're saying that State R treats a partnership as a taxable entity. It doesn't treat it as a flow-through transparent vehicle. And there are some number of countries out there that do this. The one I've run into most often, although until recently they haven't had much of a treaty network, is Hong Kong. Hong Kong treats, I believe still does, treats a partnership as if it's a taxpayer, not transparent. In this example from the commentary, you have a partner who was a resident of State R. You have a partnership in State E. State R treats the partnership and the partner as being 2 taxpayers, 2 different taxpayers. State E says the partnership is transparent and only sees 1 taxpayer, and that 1 taxpayer is the partner, is P. Under the facts, the partnership has activities which constitute a permanent establishment under the tax treaty between State R and State E. So as a result, under State E's tax analysis, they look at this and they say that P is, because of the transparency of the partnership, P has a permanent establishment in State E, we can tax him. Now, the specific example here was that P happens to sell his partnership interest and realizes gain. Now, from State E's perspective, P has sold an undivided interest in the property of the partnership. He has sold an undivided interest in each table, each chair, each asset, the inventory, the receivables. Because of transparency, he sold actual assets. On the other hand, in State R, they look at this and they say, because we treat the partnership as a taxable entity, separate from its owners, when P sells the partnership interest, P has sold something which is, in a sense, the same as selling shares of a corporation. So there's a difference between the two countries on how they're characterizing the transaction. If we go to Article 13, okay, first look at paragraphs 1 and 2. State E says that paragraphs 1 and 2 apply because the transparency of the partnership means that P has sold his undivided interest in real property, if there is any, and the property of the permanent establishment of the business that's being conducted there. So State E taxes him under paragraph 1 and 2, as the case may be. On the other hand, now look at paragraph 5, which State R looks at. State R looks at paragraph 5 and says, hey, he sold an interest in an entity, and an interest in an entity, as long as this real property situation in paragraph 4 doesn't apply. In the case of the sale of shares, that's going to mean that the only country that has the ability to tax is the country of residence, and not the country of where the entity whose shares are being sold. In other words, so State E cannot tax, only State R can tax. So you have a conflict between the two. And this type of thing, in the case of partnerships and LLCs, is very possible. Definitely not uncommon. If you have a situation like this, the OECD, I don't remember how many years ago, I want to say 10 or 15 years ago, did a report on this kind of issue. And then I think after that report made some additions to the commentary. So there is a report there, and it's, again, something that's available either through the OECD website or the Source OECD website. Now, in this particular situation, notice that the commentary suggests that this problem be addressed by our granting an exemption or foreign tax credit so that we achieve the intent of avoiding double taxation. But in practice, needless to say, State R may or may not be swayed by this suggestion from the commentary. There's one other example that I'd like to give, and this is resulting from a relatively recent case which is called TD Securities. This is a Canadian case, and essentially you have a situation where there's this is the Toronto Dominion Bank in Canada at the top, which is a large publicly held bank in Canada. It has a subsidiary, let's say sub 1 in the U.S., and then a sub 2, and then under sub 2 is an LLC, which is, I think, TD Securities LLC. This LLC happens to have had a branch, a PE, permanent establishment, in Canada. This LLC was in a significant business. It had, I think, 500 employees, major offices in New York, a lot of activity. For its customers, it set up a branch in Canada. Now, I've talked before about the concept of a branch remittance tax. Now, I don't remember, it's given in the case, although I don't remember what the detail or what the actual tax rate is. But let's just assume, for the sake of argument, that if there's 100 of income in Canada within the branch, that maybe the tax is, let's say, 30, and then on the 70 of after-tax branch earnings, there's, let's say, a 20% branch remittance tax. Now, do you remember what a branch remittance tax is? Remember, we talked about it. We said that it's in order to equate the situation of a branch operating through a branch with a subsidiary from the standpoint of the host country. So from Canada's perspective, this 70, if we had a non-treaty country company, this 70 would be taxed, let's say, at 20%. I'm sorry, I'm putting my line in the wrong place. This LLC is in Delaware. If this activity here in the branch had been conducted through a subsidiary and it had earned 100 and been taxed at 30 and there was 70 left over, when the 70 was paid by the subsidiary as a dividend, there would have been a dividend withholding tax at a 20% rate. Again, I don't remember from the case what the rate was, but let's assume 20%. So there'd be a withholding tax, and that's nothing unusual. If we look at a lot of tax treaties, there will sometimes be in the dividend article a statement that, first of all, that in the case of a dividend, an actual dividend that's paid by a company, that 20, let's say, will be reduced to 5% or 10%. And I think in the case of the Canadian treaty, I think it was down to 5%. And there was a provision that said, in the case of a branch remittance tax, that also, for a U.S. resident, will be reduced to 5%. So this made a serious difference in how much the branch remittance tax was. The issue, of course, was the LLC a resident of the United States for purposes of the Canadian-U.S. treaty? If it's a resident, then the 5% rate would apply to the branch remittance tax. If the treaty does not apply because the LLC is not a resident, then the 20% rate would apply. So the whole case boils down to, is the LLC a resident for purposes of the tax treaty? What happened, essentially, was that the judge looked at this in Canada. I mean, first of all, we have to note that the Canadian authorities, the Canadian tax authorities, because there was this case, they were taking the position that the LLC is not a resident. It's not a resident. Now, why might they be able to say it's not a resident on the surface? What do you think? What did we say was the definition of resident of the U.S.? Let's go back to Article 4, and what does it say? Is liable to tax therein by reason of. Is an LLC liable to tax therein? Assuming an LLC is a transparent vehicle for purposes of tax, in other words, in this case, the LLC was transparent. It was not under the check-the-box rules being treated as a taxable company, as a C corporation, so to speak, in the United States. It was treated as transparent. So, on the face of the language here, it is not a resident. Important to always look at what is fact and what is fiction. Fact is that an LLC is an entity established under in this case, the Delaware LLC Act, and it's a registered thing. It can own property. It can sue people. It can do all things that any other juridical person can do as a practical matter. That's reality. There is an entity here. The check-the-box rules for determining how you will treat a particular entity or a particular form of organization for U.S. tax purposes does not in any way change the fact that there is a juridical person that is conducting a business and having a branch in Canada, doing all of these things that it does. So on the face of the treaty, and in the eyes of the Canadian authorities, this is an entity, established under the laws of Delaware, but it is not a resident because it is not liable to tax within the United States. Now that's very, very clear. Now I don't know what motivated the Canadian authorities, but they certainly did not have to stretch to get to this answer. They didn't have to stretch at all to say the LLC is not a resident, is not allowed treaty benefits, and therefore the 20% rate should apply, not the 5% rate. Now, what did the court decide? The court decided essentially that, gee, we should look to a little bit more the substance and intention and the purpose of the treaty. And it also looked to some language in the commentary which is favorable in this regard, which, if you're interested, you can find. But basically they said, because we know that all of the income here is in fact going to be taxed within a tax return, because under U.S. taxing concepts, all of that will be included in here. Sub 1 files a consolidated tax return, which includes all of the income and expenses of Sub 2, and that will include all of the income and expenses of the LLC, including the income, of course, of the branch in Canada. So ultimately, the judge decided, yes, they should get treaty benefits. They should treat the LLC as a resident for purposes of the treaty. Now, that's nice for this situation, and it's nice that Canada did this, but you cannot assume that other countries will do the same thing. This is a real problem with LLCs. How do other countries treat them? To summarize with respect to partnerships and LLCs, I think, number one, there is real concern about two countries treating a partnership or an LLC as in two separate fashions. One thinks it's transparent, the other thinks it's not. And this is really true for both of them. Now, with respect to LLCs, there's one more thing I would like to go through, and that's to have you look at, again in the Japan Treaty, and I think there's, I know that there's similar rules now in the Canadian-US Treaty, just to look through maybe one or two of these items, just to get an idea of what some of the newer U.S. treaties have with respect to this issue. Now, these things can be miserable to read. One thing which I think can be helpful when you read these things in the context of, a real situation, the U.S. and Japan, or whatever it happens to be. When you read things, substitute for contracting state and other contracting state the name of the country. That'll help you, and also draw a picture. An item of income derived from Japan through an entity, X, which is organized in the U.S., and is treated as the income of the beneficiaries, members or participants of X under the laws of the U.S., shall be eligible for the benefit of the convention that would be granted if it were directly derived by the beneficiary, member, or participant of that entity, where the beneficiary, member, or participant is a resident of the U.S. to the extent that they would have if they were receiving it directly. This is now allowing the item of income to get treaty benefit to the extent that, let's say this is Canada here, to the extent of the U.S. resident members of that LLC, there can be treaty benefit. Now, we can read these things in the treaty. We can figure out what the right answer is. But sometimes actually achieving the result in practice can be potentially very difficult. Because try to imagine talking to some tax official, out in the hinterlands in Japan, and trying to demonstrate as to who is the owner of X and provide adequate documentation of their residency status. The practical difficulties can get pretty bad. But at least increasing numbers of treaties, especially U.S. treaties, are trying to deal with, because there are so many LLCs being used around the world now. You'll see actually in this Japan-U.S. treaty, there's like 5 different examples that they give. And you've got to do this kind of careful reading and picture to figure out what each one is saying. Territorial or received in country basis. There are a number of countries that have territorial systems, and if, for example, country A taxes X only on a territorial basis, then when B wants to tax and look at whether or not there's going to be a treaty benefit, say, for withholding taxes on income that's paid to X, B might look at this and say, hey, again, the reason behind these tax rules, these treaties, and the benefit we give is that there should be taxability in the other country. Now, specifically in regard to some of the territorial countries, there's a rule that says that if income is received, in other words, if X will only be taxed on the income from B, from country B, if X receives the payment into country A, in other words, remits the income into country A, then under the treaties, normally there will be a provision that will say that B only needs to grant the tax benefit under the treaty, the reduction in rate or exemption, if X in fact does remit that income. So the point is, just because there's a treaty between A and B, just because you know that X is a resident, might still mean that there's no treaty benefit if X is being taxed on this remittance basis. Territorial country that taxes foreign income when it's remitted into the country. Okay, the last one is a relatively new addition to the OECD commentary. This again is another one that you need to be aware of because it's dangerous to assume a particular company has residency . Let's say that under the AB treaty, X is in country A. There's a treaty with country B, and there's a treaty that A has with country C. Now let's say that X has management and control in country B. It's formed under country A's laws, but it's managed and controlled in country B. And under the AB treaty, because of that management and control, it is in fact resident in country B. It's resident in country B. Now, under this recent rule on this kind of situation, country C could go ahead and say to X, well, gee, since you are resident in country B under the AB treaty, we do not have to treat you as a resident of country A. I don't remember exactly when this change was made, but it's within the last couple of years. So it's trying to have some consistency and trying to prevent a company from, in effect, being a dual resident company and taking advantage of that fact. From here on, I'd like to start going sort of page by page through the treaty. First, take a look at Article 2. This is Article 2 from the U.S.-Japan Treaty. Japan has significant local taxes, and the U.S. has significant state and local taxes. And you don't see any reference to them here. This is relatively common that it's only national taxes and not local taxes. Sometimes you find them, but a lot of times you don't find local taxes being covered. I've never checked specifically, but at least my recollection from many years ago was that California had, at least at that time, a state tax law which essentially mirrored, was a copy of the U.S. federal tax law. They literally would make amendments each year that they wanted to make that were the same as amendments that were made nationally. So you had, the same U.S. law. And I assume, although I've never looked, but I assume that that means they probably have in their state law the same doing business in California provision as doing business in the U.S. and effectively connected income concept. So if you have a company, a foreign company that's doing business, let's say in California, it may well happen that they are subject to California tax on their operations, although they are protected from federal income tax as a result of the treaty. You can have that kind of situation. Article 3 is always certain general definitions. Paragraph 2, I should say, is particularly important because it refers you directly back to domestic law for any term which is not defined. Now, there's a lot of terms that are generally defined in the other articles. Not all terms are defined in Article 3. Generally, just these items that were mentioned. Another item you often find in Article 3, of course, is a definition of what the country is. You may recall on some, in some earlier session we talked about the definition of what is, for example, the United States, or what is India. Is it just the geographical boundaries, or does it include the area over the continental shelf where natural resources are pulled out of the ground or out of the sea? Often the treaties in Article 3 will have that kind of definition. We've talked quite a bit so far about paragraph 1 of Article 4, but now let's look at the rest of Article 4. Notice that here is talking about an individual who is a dual resident. This is often referred to as a tiebreaker provision. If an individual under the laws of two countries is resident of both countries under the domestic laws, how are we going to decide which one he will be formally a resident for tax purposes of? This tiebreaker provision is found in pretty much every treaty. And there's a hierarchy. You notice where this is the first test. If that test doesn't decide it, then you have the next one where he has an habitual abode. Now, I've actually never seen a real clear definition of what habitual abode means, but at least where I've seen the word used, the expression used, it seems to mean where does he spend more time. But I've really never seen what I would call a definitive definition of what that means. If that doesn't work, then item C says the next test is of which country is a national. If that doesn't work, then the competent authorities will decide. So there's a hierarchy of tests. Item 3 is now a person other than an individual. So assuming you're working with a corporation, if a corporation is a dual resident, for example, then we're looking at where effective management is. Now again, that's a management and control type of concept. Again, these rules can differ a bit in various treaties, but generally they're along this type of line. Now, starting off to put things in context, remember the permanent establishment definition is important. Why? Because when we get to Article 7, we see that income from business activities will only be taxable by the host country if the resident of the other country, its activities reach this threshold of a permanent establishment. So we have to define what is that threshold. Remember we talked about OECD model, and also there's a UN model. The OECD model again represents the have countries. The UN model represents the have not countries. Who do you think has a higher threshold for a permanent establishment? The OECD model or the UN model?
OECD.
Okay, and why?
It's probably their residents that are internationally conducting business, so the higher the threshold, the more likely they can conduct business in other countries and not be subject to tax there.
Yep, exactly right. Exactly right. Now, a little later on, we'll look at some differences between the two. Let's look at that first paragraph. A fixed place of business through which business is carried on. There's really three things here. There's duration, there's location, and there's the conduct of business through that location. You either have those three or you do not have a permanent establishment under paragraph 1. Now, you might have a permanent establishment under some other paragraph later in the article, but as far as paragraph 1 is concerned, you only have a permanent establishment if you have those three things. One of the items which I tried to beat on in some prior session was that this is a test in deciding whether you meet this threshold. You're looking at actual, call it physical facts. You are not looking at status, you're looking at activities. You're looking at physically, is there a place of business? Is there a location? Physically, there either is or is not. Physically, a certain amount of time goes on. Physically, there are some sort of business activities normally carried out through human beings. This doesn't say anything about the status of the resident of the other country, whether he has qualified to do business, whether he has registered a presence. It's totally silent. You're just looking at activities, location, and duration. You're not looking at status. Paragraph 2 is giving, as a practical matter, just some examples of typical things that typically will be a permanent establishment. Any of those items are prima facie, they meet those three tests. Paragraph 2 really does not give us much guidance. It's been there, it's reproduced in virtually every treaty, but it's not something that actually provides much in the way of guidance. Okay, next time we will continue on with Article 5, and it'll probably take us a little time to get through a number of points here, so that we have a good understanding of permanent establishment, by the time we're done with Again, please make a point between now and next time to read through the treaty, scan, especially for next time, maybe again, don't read in detail because you'll go crazy if it's too long. But at least scan through the commentary for Article 5, Article 7. I think those two would be good just to see roughly what's in there. Thank you and good night.